Hello, Anita, and hello, Amy. It's very nice to see you, ladies. Anita, you are a recurring guest here on Wiki, but it's always nice to see you. Amy, it's your first time being a guest here for the Wicked podcast, but hopefully this will be the first of many interviews with you. And I'm very happy to see you here today because both of you, because we will be talking about a case that came out recently from the Ontario Court of Appeal. It's the case of Hason, if I'm pronouncing that correctly. And it actually addressed a very important topic, and it is about expert evidence and the reliability of the expert evidence. We will be talking about this case first with you, Amy. You'll be telling us about that case and another case that is related or that served as a basis for the challenge that happened in the case of Hason, and that is the case of Nettleton from the Superior Court. And then we'll get into a broader discussion of the impact of that case and what it means in the future in cases where there will be an expert who will be relied on, and I'll be hearing from both of you on that. But Amy, if you can just start by telling us, giving us an overview about these cases that are mentioned here.
Sure. And thank you very much for inviting me to come and speak with you. So I'll start first with Nettleton. Nettleton, it was a dangerous offender hearing in Toronto, presided over by Madam Justice Bird, involving a self-represented offender. So following his conviction, the Crown brought an application that Mr. Nettleton ought to be declared a dangerous offender, and so opens up the door for a indeterminate sentence of imprisonment. So in order to be declared a dangerous offender, the Crown is obliged to file a report from a forensic psychiatrist that details any diagnoses that are available and conducts a risk assessment for the offender's future risk. So you can't get declared a dangerous offender without the forensic psychiatric report. So the role of the expert on a dangerous offender hearing is central. It's essential. You don't get declared a dangerous offender without that expert evidence, and so it can be really play the definitive piece on a dangerous offender hearing. So Mr. Nettleton did not have a lawyer, and Justice Bird appointed amicus to assist him, and the Crown's expert was a fellow by the name of Dr. Scott Woodside, who's been providing expert opinion evidence in dangerous offender hearings, largely for the Crown, for a number of years. So amicus became aware of certain mistakes that were included in Dr. Woodside's report. But what's really interesting about what happened in Nettleton is that Dr. Woodside had conducted an assessment of Mr. Nettleton back in 2019, and that assessment was updated in 2021 and 2022. And there were some discrepancies in the later reports as compared to the earlier report. Crown Counsel caught some of those early errors and asked Dr. Woodside to explain why those errors existed, and he provided an updated report. At the hearing, amicus took the position that Dr. Woodside ought not to be qualified as an expert in forensic psychiatry, which was a very bold move, given the number of times he had been qualified previously, on the basis that he was not independent. He didn't satisfy that requirement. And it came to pass during the evidence in Nettleton and during amicus's cross-examination, it came out that Dr. Woodside had a practice of using templates to create his reports in dangerous offender hearings, that he used a template to create Mr. Nettleton's report, and that the final versions of those reports contained some significant errors that included facts and diagnoses that did not actually relate to Mr. Nettleton at all. So basically, he opened up a precedent document, didn't make enough changes to that document, and even after the Crown identified the errors, didn't review the entire report. So what happens during cross-examination, and this is really what happened, what is, I think, the key to how Nettleton really is a significant case, and sort of explains what happened in Hassan, is when Dr. Woodside's errors were pointed out to him, he doubled down and attempted to minimize the errors that were there. And he didn't acknowledge their potential impact, and he didn't take the time to reconsider his opinions. So ultimately,
Amy, can I jump in just for a quarter of a second?
Please.
You're providing such an excellent and comprehensive summary. And every time I hear what happened in Nettleton, I am once again a bit shocked by it. So as you were telling it, I was like, wow, even though I totally know what happened. But I just wanted to point out, and I don't know if you were going to get to this, that the types of errors that were identified in the report are not sort of trivial nuisance type errors. So one of the things, as I recall, and I could be wrong, but one of the things that the amicus had concern about, for example, are things like Dr. Woodside in his report opines that the accused was unwilling to participate in intimate partner violence counseling, for example. But of course, Mr. Nettleton didn't have a history of intimate partner violence. That was the other fellow who had the template facts, the precedent. So things of that nature, behaviors and conduct and criminality in the past that simply didn't apply to the individual before the court. These are significant factual errors. And these are the types of errors that Dr. Woodside then goes on to say wouldn't have made an iota of difference to his opinion. The other thing I wanted to just interject early on is to recognize Dean Embry as the amicus that the court appointed. Whether Dean would appreciate our naming him or not, I don't know. But I am committed to giving credit where credit is due to Dean Embry for this cross-examination, which is foundational, as we see now, over a number of cases. And I think will change the lay of the land and how we deal with psychiatric expertise in particular. So I'll shut up now. But I just want to say these were important, critical errors that he then said, who cares about, really?
Absolutely.
And one thing, sorry, just to mention as well, is that the reason why we're also taking the time to talk about the Nettleton case is because we're dealing with the same expert in both cases. So it's, again, the same doctor, and this is why it is important and relevant to dwell a bit more on this case and why it was referred to as well. But go ahead, Amy.
Yep. I was going to use just one example. So in a dangerous offender hearing, the predicate offense is the offense that the offender is being sentenced for. So on a dangerous offender hearing, you hear all kinds of information about the history of the offender, but what you're sentencing them for is the most recent offense. And so Mr. Nettleton's predicate offense, as we say, was a note, handover note robbery. So he went to a Subway sandwich store and he passed a note that said, "Give me all your money." And the offender who Dr. Woodside used as a template was a attempted murder of 2 persons with firearms in the course of a drug deal. And so what was crazy about what happened in Nettleton's case was that as Dr. Woodside was being cross-examined on his errors, he was refusing to admit that the errors were significant enough to have made a difference. So one of the most sort of baffling was Dr. Woodside's maintenance, and he maintained the position that by passing a note in the Subway restaurant, he had endangered the life of persons around him. Well, that was simply just not the case, just plain old wrong on facts. And so that's where the Court of Appeal would sort of subsequently find that Dr. Woodside's sort of carelessness in reviewing his reports, the creation and the review of his reports, amounted to discreditable conduct evidence, which is what they did in Hassan. So Hassan was argued before the court became aware of the decision in Nettleton. They became aware of it after. They got submissions from the parties, another dangerous offender hearing. Again, Dr. Woodside's the only expert evidence on the hearing. And the court wanted to know what the impact of Nettleton should be on the appeal that they had just heard. And the court in that case found that had the trial judge been aware of Dr. Woodside's practice of using templates to create his reports, he might not have found him to be a credible and reliable expert witness, which is a pretty significant thing for the court to be able to have said. Not only that, the court found that Dr. Woodside's testimony in that case and Justice Bird's findings about him constituted discreditable conduct evidence that could be relied on in the future. So Hassan is a very interesting case for a couple of different reasons, but on the expert evidence point, really makes the point that nobody is an expert for life, and nobody can be presumed to understand their obligations to the court. So that's kind of an overview.
Thank you, Amy. Anita, before we get into the implications, I was just wondering, and that, I mean, Amy, you can jump in and answer it as well. Like, what was the what do you think caused that? Like, is it just because he had way too many cases and he just didn't want to bother and waste time, or is it just bias? Like there was some kind of bias against certain individuals. Like it's a bit disturbing to see that he was also confronted with some problems and yet kept on doing so.
Whenever I appear on Maya's show, any of her shows for Wicked, I always feel like I'd hate to be cross-examined by Maya, because she's always like, well, just for clarification, then it's something devastating, you know, that it's just a minor question to So was more biased or careless? Like, do you think negligent or purposeful omissions? Yeah, all very good questions, Mine. By the way, my regular appearances on your various shows, I hope people and Wiccan members will receive as I'm maybe one of these regular SNL hosts, you know, who returns all the time for the comic monologue. I don't know if I can answer that question, but I'll start by pointing out that in Hassan or Hason or Hassan, we don't know how to pronounce it properly, I count, and I could be wrong, but I did a sort of find the expression. I count 35 instances of the expression careless practice in relation to Dr. Woodside's approach to particularly a certain section of the dangerous offender report, which I think is the future risk of offending section. And that's found as a pattern of particularly careless practice in preparing that section of that type of report. That said, I mean, you were asking about the practices. So I won't comment on Dr. Scott Woodside sort of personally in his approach to things. And the main reason for that is I certainly have had occasion to cross-examine Dr. Woodside directly, and I practice in an area where that happens all the time. So I've been exposed to him testifying and personally have cross-examined him. But what I can comment on is what's in the public record in these actually 4 cases now that involve Dr. Woodside specifically, where comments have been made and findings, more importantly, have been made by trial judges with respect to his practices. So in Nettleton, we learned that he used templates, that he didn't necessarily review his earlier reports, even when certain mistakes were identified for him. So for example, one of the issues was the Crown had diligently identified a number of problems with the first report, but then having heard about those concerns, the findings of Justice Bird are that Dr. Woodside, and he testified to this, rather than going back to the report and then reviewing the entire report for potential errors, knowing that several had been flagged, he just went to those errors identified by the Crown and addressed those 2 or 3 issues. So that's the first thing. So we know that that was his sort of practice there. But we also know from previous cases that he had other general approaches to the preparation of other types of reports. So I think concerns broaden beyond dangerous offender applications and beyond certain sections of the report. For example, in Minassian, which Alec Minassian, of course, was our sort of van killer, putting it colloquially, and there was a very extended, the city of Toronto certainly remembers, very extended NCR hearing that went on for days and weeks with Boris Vitensky at the helm for Mr. Minassian, where the expert opinion of Dr. Woodside was probed, and Boris Witensky cross-examined, with care and attention on the preparation of the report, where Dr. Woodside concluded that Mr. Minassian was not NCR, did not have NCR available to him. And in that case, there were certainly findings of fact made about Dr. Woodside's note-taking practices. And those have come up since in other cases. So Dr. Woodside testified in Minassian that he does not retain his original notes from his interviews with accused persons, for example, which is already in my general practice at cross-examining experts, and I think we will all agree, is a bit of a red flag, because the notes that you take as an expert in interviewing the subject of your assessment should be retained. And, I do a lot of cross-examining psychiatrists in the civil side where they do capacity assessments with respect to decision-making and money. And it would be fairly shocking to that system if the original notes kept by a physician or an assessor were destroyed. But Dr. Woodside indicated that his practice is to destroy those original notes. He doesn't keep a record. And instead, what he does is he sort of copies and pastes the part that he considers relevant and then inserts them into what he called the narrative of his final report. And this leads to, predictably, errors. And one of the places, another case, so item number 4, case number 4, where the issues are again raised, is in Barwani, which you are very familiar with, Maya, because you and I wrote a chapter to our latest book together. And in Barwani, and this issue is before the court, so this issue has recently been raised by the appellant, Mr. Barwani, before the Supreme Court of Canada. What happened in Barwani was that Dr. Woodside once again did not retain his original notes of the meeting with the accused. He rendered an NCR report. As it turns out, he was the only one out of 5 psychiatrists who ultimately provided a report and an opinion on whether or not Mr. Barwani was NCR. Dr. Woodside alone opined that Mr. Barwani would not have NCR or Section 16 available to him as a defense. At least 3 other psychiatrists said that he did, that he would meet the criteria. So Dr. Woodside, again, did not keep his own notes with respect to that interview. However, in Barwani, as the record reflects, he had a student with him, a psychiatric resident or a learner with him, who did keep her notes. And her notes directly contradicted some of the conclusions and the recitation of what Mr. Barwani said in that interview. And these things were very salient. They go to things like whether or not the accused had sex with a woman after killing her, for example, things of that nature. And so Dr. Woodside, for example, said he said that he did, and the student's notes say he thought about it, but ultimately didn't do it. So again, like not insignificant types of distinctions in terms of how Dr. Woodside recalled the responses from the accused that he was assessing. And this is to the best of my recollection. So there are certainly patterns. I mean, your original question was, is this bias or is this negligence? So don't know what goes through people's minds. We have 4 cases where questions and concerns have been raised on the record based on Dr. Woodside's explanation of his method and his approach to interviewing and assessing accused persons in criminal justice. And there are certainly practices that are unorthodox that risk significant errors in coming to a conclusion. And there are now 4 cases where these concerns are being raised from trial level, Superior Court, Court of Appeal, and now in front of the Superior Court. So certainly his regular practices are questionable. But on the issue of bias, while I wouldn't comment on that, what I will say, and I think Amy has some important thoughts on this, what I will say is across our systems, we should all be concerned about hearing from experts, particularly when they're the only expert on the ultimate issue to be determined by a trier of fact. We should all be concerned about an expert whose resume reveals that 90% or more of the time they testify in support of the position of one or the other side of the criminal justice system, that they are either retained nearly in every case by the Crown or equally by defense. So I would say that the concern is for both sides. And I think that's a problem systems wide.
Well, but the other concern as well is how long has this practice been going on for? Like, is this something that he's been doing since day one that he's been practicing, or is it something that with time that he started? Because then the issue would be for other cases where he was also the expert, like, should they go and revise their cases? Like, what should happen at this point? I don't know.
Okay, Amy, I give you all the easy questions. Amy, you're up.
Well, I'm not sure what's going to happen. I haven't heard anything officially. I'm not, so take everything I say with a grain of salt. Certainly, if someone has a case involving Dr. Woodside that is ongoing, there has to be some real thought given to whether or not it's appropriate to proceed with Dr. Woodside as an expert. Now, ultimately, the test for the admissibility of any evidence is going to be whether the probative value exceeds its prejudicial effect. And I think that the message sent by the Court of Appeal in Hassan is that the issues in Nettleton give rise to real concerns that need to be explored. So where he's currently an expert, the issues of the preparation of the report, the existence of any errors have to be explored at the very least. So there's that. For cases that are where he's given evidence, one of the problems from the defense side of things and sort of becoming aware of issues like this, the use of templates to create reports, that's not going to be something that's readily apparent to defense counsel who doesn't have access to all of those reports. So with questions about a systemic issue would more properly, I would think, be the subject of an inquiry like that of involving pediatric forensic
The gouge.
the gouge inquiry with Dr. Smith. So that might be one of the things that happen too. But certainly, if you're working on an appeal involving Dr. Woodside, Hassan says you can rely on Nettleton to raise this issue, and so you're going to be looking at issues like what was the cross-examination of Dr. Woodside like? Were any errors identified in the report, and what were his explanations for those errors?
Right. So let me just stop you there. Sorry to butt in, but in Hassan, Chief Justice Tulloch makes it very clear. There's a caution to say, what we're doing here doesn't mean that every single case where Dr. Woodside was involved is going to be sort of automatically overturned or problematic or needs to be reviewed. That said, Amy points out it's what happened in trial is very important. So in Hassan, trial counsel for the appellant did raise concerns about the reliability of Dr. Woodside's report. So again, it's about preserving the record and ensuring that these types of concerns are raised at the relevant time. It's always, even with this type of history, always difficult to complain in the absence of that if you don't have the record and raising some like this for the first time. So what made the nexus here is that there were concerns raised on behalf of the appellant in Hassan, specifically about the reliability of Dr. Woodside's report. But then the important piece, as Amy explains, is you don't have to relitigate Dr. Woodside's quote unquote careless practices. And this isn't me saying that. It's a Court of Appeal saying, in effect, you can take as evidence in this case that you're now reviewing the trial judge's findings about his approach to certain types of report preparation, which is going to make life easier for defense counsel who want to raise it as an issue. So that's kind of a very important thing, among other very important things about this case out of the Court of Appeal. And when I comment on this case, I feel funny saying this because it's not my place to be proud of our Court of Appeal, but I am proud of our Court of Appeal, and I am proud to be part of an entirely and truly wholly independent judicial system. Because our Court of Appeal didn't hesitate. Counsel involved were prepared not to make an issue of this at the end of the day when canvassed. And despite that, the Court of Appeal said, we are the final line of defense against injustice and unfairness. And we are raising this, and we think it's so significant that we cannot let the sentence stay. So, yeah.
But one thing that I also wanted to ask you ladies here is that in these cases, the latest cases with Dr. I keep forgetting his name. Sorry.
What
Just
side? I don't. You're the only one
yes.
forgetting his name. Yeah.
So sorry. It's because there were some, I mean, it was, there were some mistakes that were spotted because he was relying on previous templates, and that obviously did not exist in the case that was under question. So it became problematic here, and we could see that there was a problem. But what about in other cases where we can't detect, we can't really see, and there could also be some problems in the way the expert or the psychiatrist is practicing, but we don't have something that is so apparent, like in this case. So what should counsel do in the future from now on when we're dealing with these expert reports? Like, how should we approach them just to make sure that we are not letting experts who have problematic practices give their reports and just be admitted just like that into court?
Okay, well, you know what? Amy, do you mind if I just jump in? You can. So 32 years I've been at the bar this September. So right now it's 31 and a bit, but at the end of this September, it'll be 32 years that I've been a practicing lawyer in Ontario. Still almost a junior lawyer in Nunavut, 10 years in, but 32 years in Ontario. And I realize now every single day, weekday of my career, pretty much somewhere between 1 to 4 cases I've litigated where the only witness is generally an expert, a psychiatrist. So that's how much cross-examining of psychiatric experts I've done. You do the math on 32 times 365 times somewhere between 1 and 4 or whatever. And that's a lot of experts that I've asked questions of. And early on in my career, and probably still now, the psychiatrists I've cross-examined, and the tribunals and the hearings and the judges and anyone who watched me do it were certainly initially taken aback and very irritated by the fact that the doctors were being cross-examined at all. And you still see that sometimes in the system because there is an institutional bias in favor of the presumption that these expert witnesses, any doctor, any psychiatrist, certainly any forensic psychiatrist, is giving you the gospel, the absolute truth, and that their opinion, really, it's perceived often as an impertinence to question their opinion evidence. And that's a problem that infects the defense bar as it does the judiciary sometimes. So defense lawyers are really good about knowing that cops lie. And we saw the Zamir case recently, and we saw the public's reaction, for the first time learning that police officers will sometimes lie on the stand. And the public was, shocked and appalled by it. And the defense bar said, and water is wet, because defense cross-examines police officers all day, every day, and they know to expect that there will be times that officers will be untruthful on the stand. The defense as a bar has not quite absorbed that reality as it applies to experts and particularly psychiatrists. And I don't suggest that psychiatrists lie through their teeth all day, every day when they speak. And certainly the majority of the time, a lot of them are my good friends as a result of my career, and they are, hardworking, full of integrity, independent, take care with these reports. And those are the psychiatrists who see the humanity of the individual and the situation of the individual and appreciate the power that they wield when they come into these courtrooms and declare that someone should be put away into prison system for potentially the rest of their life. Let's not forget the difference in Nettleton between what Dr. Woodside should happen to Nettleton is the only way to keep the public safe, in other words, go away forever, versus what ultimately happened, which was a 5 or 6 year prison sentence that he would serve 3 of, is an enormous difference to that young man's life. And that power is in the hands of that single forensic psychiatrist and their report and their evidence. So as a psychiatrist, you need to appreciate the full weight of your power over this generally vulnerable individual's whole life. And the ones who are good at what they do feel the weight of that responsibility and approach their task at hand with gravitas, seriousness, care, attention, and thoughtfulness. That said, Dr. Woodside is not the only one who will leave you with the impression that they trust their own judgment above all, even in the face of other evidence. And I think what led to Justice Byrd's decision ultimately, Dr. Woodside's position in being so intractable about things exacerbated the situation, because he refused to admit that he may have been wrong, and he didn't want time. He was offered the time to go back and revisit and rethink to see whether the correct facts being brought to his attention might change his mind. So it's not even, he didn't even want to reflect on whether he might have been wrong. So I think an essential ingredient of the independence and the open-mindedness and the utility, the appropriateness of a witness is recognizing that they may be wrong. And so the witnesses that I trust the most are the people who say, I could be wrong. Let me tell you what I reviewed. Let me tell you what I saw, what I heard, who I spoke to, how I came to my determination, lay your process transparent. And at the end of the day, say my conclusion, for what it's worth, is the following, but I could be wrong. And that's an expert that I would trust. So in terms of what I say to defenses, they are experts, but they are not gods. And we have to guard against putting these psychiatrists and these experts on a pedestal in a way where we deify them and we're afraid to touch their evidence. I was at a conference once when one of our members of our defense bar said, you do not ever want to test the credibility of a forensic psychiatrist in these proceedings or psychiatrist. And if you do, let us know, because we'll bring the popcorn, because you'll get nowhere doing that. And I remember at the time thinking, I'm not 100% persuaded by that. There will be occasions where it's necessary to test credibility and reliability, particularly if there are red flags. And we must not be afraid. But our duty is to our client, and our duty is to test the evidence, same as you would any other witness. You need to clarify the record and go through, satisfy yourself that the expert has done the things that would qualify them properly as an expert, including that they approach with an open mind, that they're truly independent, they are truly qualified, and ask about their process. Go through everything, and you'll see where the problems are. It's your job to expose the cracks in that opinion, particularly when that's the only opinion that could condemn your client to prison for the rest of their life, or in another context, to a psychiatric facility for detention for the rest of their life.
But one point that I also want to make that you made earlier, Anita, that I think actually is a very good point, is that you have to also be careful.
So surprised. You said something.
No, but you did say something really important, and I really want to
stress. Squirrel. Yeah.
So I mean, I think we should also, as defense lawyers, be a bit more cautious when we're dealing with an expert who's routinely called by the Crown, right? Like, I mean, that for us should be like, well, okay, then maybe there's bias there, or maybe, like they absolutely want to find something that is what the Crown is asking them to look for. So that's also something to keep in mind. And I know that you said lawyers should not be afraid to ask about the process, but if you can also clarify, what exactly should they be asking to know what that process is?
Well, I mean, on the face of the report, any good report will very clearly set out exactly what documents were reviewed, exactly what, who was interviewed by whom. Often you get this weird stuff from psychiatric experts where they can't be bothered to really talk to the people involved in the life of the accused, but they'll write down that there was an interview with the mother or something. But it turns out that they sent the social worker to interview the mother, and then they asked the social worker, how did it go and stuff, right? So really, you need to probe into all of that. And you need to ask for underlying notes. So for example, if you followed a sort of checklist of what you want from the expert in the normal course, it would have been discovered very quickly that Dr. Woodside or another expert has destroyed their original notes of the interview, because you simply would have asked, you have the right to the notes that everybody took before the preparation of a report. So we don't really have the kind of time where we can get into this in some detail, but I can tell you there are lots of good materials out there on how to effectively cross-examine psychiatric experts. One of them was written some number of years ago by now Justice Paul Burstein, just regular Paul Burstein, as he was then known, which is a really solid paper, which I can find and share with our viewers if you want. on all the things you're supposed to do. But the first thing is to, particularly as a new defense lawyer, learn what an independent, proper, fair, open-minded assessment process looks like, and then have a list of things that you want to assure yourself that, the psychiatrist likely followed an appropriate process. And the person who does their job right has no problem assuring you of that. They will not take it personally if you ask them, did you speak to this person? Did you review this report? They'll just tell you yes, or they'll say, I don't recall that being provided to me. And if you ask them, could that make a difference in your opinion? Most of them will say it might. I would have to see what it says. So there's an appropriate way to proceed with these things. And then there's the way of people who've been around forever, who have become used to not being challenged on the stand. And that's where this sort of cavalier attitude to things comes from, because we have all, as a justice system and participants and judges, can telegraph to these psychiatric and other experts that we look up to them, that we're worried about bothering them, that we're grateful that they've come to court. The number of times that a judge opens with, "Thank you so much, doctor, for coming." When last were you welcomed into the courtroom and thanked for coming? And one of my colleagues tells this great story about, you walk into the criminal court and the judge won't even look at you. Every adjournment request is more important than your case. You're going to be called last. And then the psychiatrist or the doctor walks through the door, and how light comes through the ceiling. People are, falling down, saying, "The doctor is here." Everything stops because the doctor is a very busy man. Maybe they need to go on vacation. We can't adjourn the matter. We're going to make these findings right now, regardless of the procedural rights of the accused. That has got to go. We've got to have information up front on your resume. How many times have you testified for which side, when? And I agree with Amy. I think a reckoning for forensic psychiatry, it's like the Me Too movement, is perhaps overdue, and perhaps something in the nature of the gouge inquiry is actually necessary in psychiatry to answer all these questions about, what should be happening, and come up with some code of conduct and some process to guard against these kinds of systemic cracks. I'll shut up because Amy knows more about this than I do. But Amy's muted.
I know, but I would say I think that very often defense counsel is maybe not taking advantage of the qualification voir dire. And there's nothing wrong with saying, Your Honor, I have no doubt that this witness has the academic qualifications and the experience, but I think I would like to ask just a few questions about their understanding of the role of an expert. And we saw that a lot more post gouge inquiry, and then it sort of fell away again. And I think the only way you can help one another or build a record about particular experts, or develop a vibe about what's going on out there, is by just taking a few minutes to ask those questions. And it could be difficult, I understand, because sometimes, there's only one expert, there's only one report, and there's good and there's bad in it. And so you want to have a relationship with that expert so you can pull out what's good in that report too. But that doesn't, and it shouldn't be dependent on a very friendly stance towards that witness. A good expert is going to appreciate the opportunity to explain to the court that they know why they're there, and they understand their role, right? They'll welcome the opportunity to give themselves more credibility, rather than being taken aback by the suggestion that they should be questioned at all.
And a good expert will take care in the conduct of their career to actually make sure that they accept retainers in roughly equal measure or close enough from both sides of the equation, so that they don't appear, because the appearance of justice and doing justice is just as important as doing justice. So I think those really, good psychiatrists are careful to ensure that they get retained by both sides in relatively equal measure. And they will also have a demonstrated history of not necessarily providing the opinion to the party who retained them that they were looking for. And this is irritating for us as defense counsel sometimes, right? Like
Yeah.
we shop around, we all know who they are, we talk to our colleagues, and we think, okay, I'm going to hire this guy, and he's going to be very defense friendly for me. And then sometimes they come back and they say, no, sorry, not what you want. This person is or is not NCR, but it's not what you thought I would say to you, and sorry to disappoint, but this is my opinion. And that's the expert you want. That's the expert you want, no matter what. You want the integrity and the genuine independence on that score. Another complicating factor that we hesitate to talk about openly, but we should consider, is that the Crown is able to pay these experts significantly more than we can when we're retained on legal aid retainers. And that, of course, is a built-in systemic incentive for forensic psychiatrists and other experts to be retained by the Crown. If you add up the amount of money that just Dr. Woodside, poor thing, was paid, and which is again in the public realm in Nettleton for his 3 reports in the end that were referenced, and I forget, but it's perilously close to like 80 grand. It's like $40,000 per report. And I found that number significant because that is not what we're able to pay on legal aid. We're restricted in the number of hours, we're restricted in the amount of time per hour that we're able to retain experts on in legal aid. We are also constrained by our experts' ability to go into the jails and conduct assessments in custody, and the additional time and effort and difficulty that causes our experts. So I think if we did have an inquiry, some of those issues, similarly to the gouge inquiry, would be exposed. And I personally would be in favor of an inquiry with respect to the systemic issues in forensic psychiatry. I forget where we were. Where were we?
I don't know.
We were somewhere good though.
Yeah, but I wanted to ask you a question though, because I mean, Amy, you did raise this really good point of not being afraid of going for a qualification voir dire. But sometimes some of the problems that we have is that, especially some experts who, like Anita, like you said, that they're really highly respected and they're considered like almost gods, like whatever they say is the truth. You can't challenge that. So sometimes, especially for newer lawyers, I think more senior lawyers, they will have the confidence to say, no, I want to qualify that expert. But for newer lawyers, it may be something a bit daunting and scary to actually want to, and you may also get some pushback a bit from the Crowns, or they might make comments to make you feel like, as a new lawyer, that you really want to, qualify this guy or this expert. So just from a perspective of a new lawyer, like in these types of situations, like what advice would you give them on that?
I think anytime you're kind of coming up in a David and Goliath situation, I can only talk about what's worked for me, is if you just kill him with kindness, Dr. So-and-so, for my own edification, can you tell me, how many times you've testified for the Crown? I see that you've testified for the Crown, but have you been retained by the defense? And, like a sort of you can get a cross-examination of an expert that's very friendly can actually get you to a lot of places, because when, and it sort of can play on someone's ego. It works with, expert police officers too, right? Please just help me understand how you do such an awesome job. And you'll be surprised what kind of answers that'll get led to, right?
Psychiatrists, like lawyers, are not shy to talk about themselves. Most of them would love to talk to you about their careers and what they've done. They've each got 70 to 100-page CVs.
Yeah.
And I think if you had all the time in the world, they would take you through every paper they've ever written. So I completely agree with that. Can I see your CV? Ask for their CV and take them through and say, I saw you did this and you did that. Okay, but have you done this? And you just sneak it in there. When last did you testify when retained by defense? And if you hear it's been 10 years or I can't remember, red flag.
Yeah. And you could follow up with, do you know why?
Yeah. Is it because you get paid more by the Crown? Is that like, or you just
does it bother you?
Putting people in jail? I don't know. Yeah.
Yeah. Like yeah.
Or just go straight for Maya's question. Is it more negligence or bias that drives you? Would you say it's more? Let me give you an example of how. So So even though I'm older and not new, I still face a situation where I have a doctor, psychiatrist opining, let's say, in the review board context with an NCR accused, they'll say, it's my opinion that this accused continues to meet the significant threat threshold to keep them under the criminal justice. Like just a simple thing. And then I start asking questions about the basis of that opinion, though. Like, so if not under the board, is it your evidence that they will commit a serious criminal offense, or more likely than not to, and so on? And sometimes review board panel members will stop me and say, counsel, where are you going with this? How do you mean? I'm asking, I'm probing the evidence. Yeah, but the doctor has told you already. And what? That your client is a significant risk. No, I heard him. Okay, but that's their opinion. I understand. So why asking these questions? I'm probing the basis of their opinion. They say, yeah, but he's the doctor. He said, no, I understand. And he's an expert. I understand. And that's his opinion. I also understand that. But sometimes you have to explain, and you just have to remind yourself, what is your role? Your role is to probe and examine the evidence. You're there on behalf of your vulnerable client. There's a huge power imbalance, and you're building a record. And I'm always thinking about the appeal. Sometimes if I've lost the panel, and it's clear that whatever the doctor says is gospel, and I'm just annoying them now, and they're getting angrier and angrier, that's okay. Now I just need that record, because I can't complain about something that I didn't do in the hearing room. It is hard when you're new. It is young. It is young. It is difficult when you're young. You just have to breathe and not let the pressure of the clock or the pressure of the decision maker derail you. Just have to compose yourself and be very single-minded about the task at hand. You're just doing your job. And the attitude you get from decision makers is, why are you so difficult? Why are you making so much mischief for the process? Why are you dragging things out? We've already heard it is what it is. But the underlying assumption you have to understand is that our clients are criminals. They're dangerous, they're probably lying, and they deserve to be locked up. Whereas the doctor is the consummate professional who's been to school forever. The presumption is they're going to be believed. They're the experts. It's our right, our client's right, to probe the qualifications, the process, and the opinion when their life depends on it. That's what you're there to do. Now, one more thing to tell you about, if you can imagine, I had a case in the Court of Appeal that went to the Court of Appeal because a woman signed off on a report, on an annual hospital report in a review board context, as the attending psychiatrist for the client. Questions arose at the hearing as to whether or not that woman was actually a psychiatrist. And the counsel for the NCR accused asked to establish the qualifications of the doctor that was being held out as the attending psychiatrist. Everybody lost their mind. Like, everybody in the room lost their mind that these questions would even be raised. As it turns out, there was lots of cause for alarm. There had been some research done, and the doctor was a medical doctor who was internationally trained and had requalified in Canada. But upon every attempt to pass their further licensing exams in psychiatry, continued to fail those exams. This was all sort of publicly available on the College of Physicians and Surgeons website. We had to go to the Court of Appeal because the review board would not permit further questioning of this issue, despite that concerns had been raised. So you think about a vulnerable person who was in seclusion for, I think, months and years in this very secure environment, who cannot get an answer to whether or not the person who's treating him is a qualified psychiatrist, because our system considers that these are offensive things to bother the nice doctor about. But to go all the way to the Court of Appeal, where the question remained unanswered until our Chief Justice, as the lawyer for the hospital at that time, Chief Justice Straffi, finally put the question to the hospital's lawyer: is there some reason why you can't answer whether or not this physician is a duly qualified psychiatrist in the province of Ontario? Think about a justice system that forces a vulnerable accused in this situation to go to the province's top court, try and get that answer out of the mouth of someone. That is the sort of a fairly delusional level of esteem in which we hold these people, that it's considered insulting, inappropriate, rude, and troublemaking to ask whether or not your doctor has qualifications. Like, think about if you went into your GP's office and you asked, sorry, are you an actual doctor? Whether anyone would be troubled by you wanting to know if it's a physician who's treating you. And think about what our justice system does with these witnesses. So you're up against that, but don't let that fool you into thinking that you are in the wrong and that you're not permitted. You must not ask difficult questions. These are not difficult questions. These are basic questions that should just go real quick. And if there's going to be a problem and pushback, that actually is a red flag.
And we did talk about the impact that this case will have on defense and how the things that they should be looking at from now on, given like the red flags that came out from these recent cases. But I was wondering, what should the Crown do here? Like, should they change the experts that they're dealing with now? What are their obligations after these recent cases and what they brought into light?
Well, I think cases like these are, everyone has to sort of engage in some self-reflection and take a look at the process by which the Crown is picking their experts, and perhaps reevaluate from their own perspective. Is there the credibility of our experts? I mean, yeah, everyone's got to stop and look and say what went on here and how come, and really think about whether or not there ought to be policy around who's being chosen and when and why and for what. And I think that, you know, from a resource point of view, it would be helpful if that was part of it too, because an expert who can't afford to testify for the defense is not a very independent expert at all. And if we're not properly funding both sides of the question, then we're only going to get certain kinds of answers. So big problem that defense experts aren't funded through legal aid the same way. Big problem.
Amy and I were talking about this a couple of nights ago together, and she made a really good point, which is, and you asked the question, like, what are we looking for in the best experts and the experts that we want on all of these cases, particularly where vulnerable individuals are concerned? And I think Amy had the right answer. Is ultimately the expert you want is the expert who couldn't care less, to whom it makes no difference which side has reached out to retain them to write the report. Like, their opinion should be whatever it is, based on the information that's available to them, regardless of who's asking them to look at the case. And there's nothing that says we can't establish that kind of system either. Like, there are variations and formulations on these systems across the world, right? There's peer review systems. There's, you know, it's possible to conceive of a system where a rotating, list of psychiatric experts are given briefs to examine and provide an opinion. You know, taking away the middleman or woman, taking away the funding issue, and just have a system where you get expert opinions from qualified experts who've been, duly qualified through a systemic approach, a fair approach. You just take a handful of, for example, forensic psychiatrists who are known that they have the necessary expertise. You give them the brief, they spit out an opinion, and then you can hear from them on the stand, and both sides can test the evidence. Wouldn't that be a fair way to approach it without the discrepancy in funding, without the discrepancy in resources? So I think there are a lot of people who have a lot of thoughts about this. And I feel bad because I have cross-examined probably every psychiatrist in the province. I know a lot of them. And I want to take some care to say, this is not, a broad and without exception indictment of the whole of the profession. So this is not to say everyone's corrupt or everyone's negligent or everyone's biased or everyone's, useless, or there's anything particular about the profession. Whatever is wrong systems-wide is as much the fault of the defense bar, the judiciary, the entire system, for the pedestal we put them on and for how afraid we are to bother them with just an ordinary inquiry to make sure that we have trial fairness. So it's on us. And we've, lulled them into this false sense of security where they're not expecting to be challenged anymore. And I think that leads some of them to know that they can get away with sort of extrapolating more and more beyond what they basically do understand. So there's a lot that we need to pay attention to and correct in order to ensure trial fairness and the credibility and reliability, utility of these reports and the evidence of these witnesses. But there are also most of the mental health professionals on the ground are well-meaning, diligent, committed, careful, thoughtful, and human. One of my psychiatrist buddies was going out to do an assessment of an accused and make a home visit. And the accused said, "I'm glad you're coming over because my toilet is blocked. So could you bring a plunger?" And so he did. He went to the store and bought a plunger. So I'm saying there are human people out there doing this important work, and they have the necessary training. I don't want anyone who's watching this special episode to be left with the fact that we hate all psychiatrists, and especially forensic psychiatrists. I think the message is you're there to do a job, and you must be unafraid, same as you are in every other trial and hearing on behalf of your client who's charged with a criminal offense and risks losing their liberty potentially for a long time or ever.
Right. Well, I see the time here, and ladies, I don't want to take more of your times, but if there's anything else that you wanted to make, any other comments about the Hason decision that you wanted to bring to our audience's attention, or just final remarks about just cross-examining experts from now on and the things to pay attention to?
Well, I honestly couldn't have said it any better than Anita just did. And go out there and be brave and have fun with it too. Engaging an expert on their area of expertise is going to be fun.
It's so fun that once I started doing it, I've never stopped, and I never wanted to do anything else. Personally, my personality is well suited to, particularly when they get their backs up and they're super arrogant, they hate being bothered with questions, and it irritates them if they think that you know more than they know, or that you're acting as if you know more, and they get their back up. That kind of fight, when they start dismissing you and underestimating you, and I just personally find it, as Amy says, a ton of fun. So it's an experience, and when you get good at it, it's really satisfying. And not just because it's intellectually fun for you and it's a little battle of wits, but because what you're actually doing is standing up between someone with power and someone without, in between them, and you're that buffer, and you're protecting in that moment your client against the power of the state. You're doing all the things that as defense lawyers you're here to do. So I really appreciate the opportunity to talk about this. I feel like I've gotten some stuff off my chest, and also to hear from Amy about it, who's always so thoughtful and so articulate. So thank you for the opportunity, Maya, and I hope to come back next week with something else.
No, thank you both. It was really very nice to hear from you, Amy, for the first time, and always Anita, and to learn from your expertise in this area, because this is something that both of you do all the time. So thank you very much. And really, I really like the advice that you gave, Amy. You have to be brave, like in these types of situations. Don't be intimidated by the expert and their 30 plus or 20 plus years of doing this and testifying in court. So thank you so much. This was a very interesting chat and a discussion, and I hope to see you both very soon again.
Thanks very much.